Today's topic is the legal standard of beyond a reasonable doubt, the final standard in the series on the 5 standards of proof that are most relevant to law enforcement officers. I'm Steve Cerbalic, and I'm a panel attorney with AsCops in Arizona. As always, this is a topic summary and not legal advice. If you have questions about your specific circumstance, make sure that you consult a lawyer. To briefly review the 5 standards of proof most relevant to officers, in order from the lowest standard to the highest standard, are reasonable suspicion, probable cause, preponderance of the evidence, reasonable likelihood of conviction, and beyond a reasonable doubt. Last week, I covered reasonable likelihood of conviction, the standard that's used by prosecutors to decide whether to bring criminal charges. Beyond a reasonable doubt goes even further. It's required by the United States Constitution's due process clauses of the 5th and 14th Amendments. And it makes sure that people accused of crimes are protected from conviction, except upon proof beyond a reasonable doubt of every fact necessary to constitute the crime with which he's charged. So this standard instructs the fact finder, a jury most of the time, to only find for a conviction or for certain sentence aggravators if they determine that the evidence supports the finding beyond a reasonable doubt. In contrast, a reasonable doubt is doubt based upon reason and common sense and may arise from a careful and impartial consideration of all the evidence or from a lack of evidence. On the other hand, proof beyond a reasonable doubt is proof that leaves a fact finder firmly convinced that the defendant is guilty. You should know that the firmly convinced language that I quoted has been repeatedly upheld by the Ninth Circuit, but its use isn't required in defining how reasonable doubt is specifically described in state courts. Finally, remember that in order to get to the beyond a reasonable doubt question, all of the other standards of proof, reasonable suspicion, probable cause, preponderance of the evidence, reasonable likelihood of conviction, would already be met. But even if those standards are met, a jury will not convict if they have reasonable doubt as to one or more of the elements of the crime in question. When this happens, the defendant is acquitted, but because the standard is higher in criminal cases, even after an acquittal, they could still be found responsible in civil litigation with its preponderance of the evidence standard. So that wraps up the series on standards of proof. I'm Steve Cerbalic. Thanks for watching and stay safe out there. If you're interested in watching another relevant video, click up here. And if you would like to subscribe to the channel, click down here. And then hit the notification bell to receive messages when new videos are posted. Videos come out every Sunday at 5:30 p.m. Arizona time.